Good evening, everyone. My dear friend and an eminent lawyer, Mr. Tejasvi Surya, young, energetic parliamentarian, one of the few handsome parliamentarians. My dear friend, Mr. Vishu Bisoya, and all dear friends. Friends, I am aware that today is Sunday. It's evening of the Sunday, and all of us are really grateful that you have been kind enough to be here with all of us to discuss about something which is not a very pleasant thing to discuss. Namely, as the name suggests, abuse of the Constitution during the emergency. I'll take a slightly different approach while dealing with this subject. Friends, we are since last about a decade listening to certain phrases. The phrases like majoritarian regime, there is an arbitrariness in the governance, there is no independence of judiciary left, the interference of government in the functioning of the judiciary, etc., etc. We are all by and large lawyers, and therefore when we deal with such arguments, our arguments cannot be the arguments of a layman, and we must confront this kind of factually incorrect propaganda with some kind of a legal logic. And my attempt would be that the era of emergency, namely 75 to 77, was definitely the darkest period in the history of post-independent democracy. It was just the climax. The abuse of the Constitution was not just during the emergency, but it started much before, and all of us must be clear about it. I'll just give a brief background and I'll not go into the nitty-gritties or details because all of us are lawyers and you know the basic fundamentals. Basically, we have a constitution. When country becomes independent, how the country becomes independent? It's not as if from tomorrow Lord Mountbatten says that next day morning I have a flight and Nehru takes over. That's not the way in which independence of a country takes place. It takes place by way of an enactment called Indian Independence Act 1947. It was passed by the British Parliament. That's not relevant for the present purpose. The relevant is that under that act there was a provision that there would be a constituent assembly which would make the constitution. I'm not again going into the statistics, but please bear with me. The figures are correct. The Constituent Assembly represented 16% of the population of the country, but they were brilliant minds, one of the finest minds in the country, and they made a constitution which was here to last unless tinkered with. And my attempt would be how the constitution was tinkered with. We will not be political, but there would be some facts where inevitably some political names are bound to come, and we would be doing injustice to the subject if we shy away from doing that. Now, the constitution is in various parts, but today for this subject we are concerned with only three parts. One, the preamble. Second, the fundamental rights. And third, the power of amendment of the Constitution. Preamble, everyone knows. India is a sovereign democratic republic and we have given to ourselves this Constitution. No further discussion is necessary. Part 3 of the Constitution provides for the fundamental rights which I enjoy, which you enjoy, which an ordinary farmer enjoys, and lowest of the low in the rung of economic hierarchy enjoys. Now please bear one provision in mind when I point out the journey, how the constitution came to be abused day after day, and how there was a confrontation between the government of the day and the judiciary of the day, and I will come to the emergency thereafter. The first provision I would wish you to keep in mind is Article 13 of the Constitution, which provides for the definition of law. Law here, in the context of the Constitution, does not mean the law made by the Parliament or law made by the Assembly only. It may include rules, it may include regulations, it may include even bylaws, it may even include custom and usage. It's a very widely worded definition, and the reason is simple. The fathers of the Constitution, the framers of the Constitution, desired to make a provision that there cannot be any law. Please keep this in mind throughout. There cannot be any law which violates fundamental rights of the citizen, and every game was played by the government of the day to change the definition of the term law. And I'll take your lots to the audience to the journey very, very briefly. The first Prime Minister Nehru had a dream. It was a dream for the nation. That was for the purpose of agrarian reforms. The first election took place in the year 1951. Till then, as per the Government of Indian Independence Act, the Constituent Assembly continued as the Parliament of the country. The first Parliament was constituted in 1951. The first amendment was introduced before the first Parliament was constituted, whereby Article 31 capital A was added, which provided that if the Parliament were to make any law concerning the agrarian reforms, the reforms concerning the agricultural community or the agricultural land, it cannot be challenged in any court of law, even on the ground that it violates the fundamental rights. That was the first amendment to the Constitution. Second, when the Constitution was framed, there were 395 articles and 8 schedules, various schedules, the powers of the legislative competence of Parliament, legislature, which are the official languages, etc., etc. For the first time, a new schedule came to be added, namely Schedule 9, with a provision in Article 31B that if the Parliament makes any law and puts it in Schedule 9, it again becomes immune from challenge on the ground of fundamental rights. So if Parliament were to make a law and put it in Schedule 9, even if it violates my fundamental rights, I have no remedy of redress going before the High Court or the Supreme Court, or for that matter any court. This came to be challenged before various High Courts, essentially before Patna High Court, Allahabad High Court and Madhya Pradesh High Court. I am not going into the nitty-gritties. One High Court declared it to be unconstitutional. The amendment came to be declared unconstitutional. Others upheld it, but eventually it came before the Supreme Court of India in the first case, that is Shankari Prasad case. In Shankari Prasad case, the core question was, what is the law? When the Parliament has amended the Constitution itself, can that amending act be called a law? See the distinction. Parliament making a law regarding land is one thing. Here Parliament is making changes in the Constitution itself, and the source of that power is Constitution itself. So essentially the question was, can the Parliament's power to amend the Constitution be challenged on the ground that that amendment itself violates my fundamental rights? The matter went before the 5-judge bench. 5 judges bench, they examined and said that the act by which the constitution is amended is not a law within the meaning of Article 13, and therefore, even if it violates any of your fundamental rights, it can violate fundamental rights. It would not fall foul of the test laid down in Article 13. Very unfortunately, this position continued for 14 long years. 14 years, Parliament makes the law, puts it in Schedule 9, and even if it violates the fundamental rights, nothing can be done. Suppose my land is taken away. I cannot say that it is taken away without following the process in accordance with law, and therefore violative of Article 14, because I don't have the protection of 14. I can't say that there is a discrimination. My neighbor's land is not taken and my land is taken. There is an apparent discrimination. Nothing can be done. The Supreme Court 5-judge bench in Shankari Prasad upheld that position, and that legal position continued for 14 long years. The government of the day kept on making laws and kept on including it in Schedule 9, and therefore making them immune from any challenge. And the Schedule 9 contained by that time 30 acts. So 30 acts which can affect my life, your life, any citizen's life, and it can violate the fundamental rights. Then comes Sajjan Singh's case. Again, this question is raised. The core question was that let us have a look whether Parliament making some law is different from Parliament making an amending act, amending the constitution itself. Let us have a real look, but again went before the 5 judges bench. Again the 5 judges bench upheld the power of Parliament to amend the constitution, and that amendment would be valid even if it takes away the fundamental rights of the citizens. The 5-judge bench was 3-2. It was not unanimous verdict. It was 3-2. The dissenting judges were Justice Hidayatullah and Justice Mudholkar. They were in minority. They gave a dissent. Justice Hidayatullah, one of the most eminent jurists, eminent judges of India, who eventually became the Chief Justice of India and thereafter became the Vice President of India. He said, I am not a grammarian. I will not go by the grammatical meaning of the word law. I will go by the spirit. The spirit of Article 13 is that if any law made by the Parliament violates the fundamental rights, it is void, it is ultra vires, it is non-est. Interestingly, in Sajjan Singh's case, which is 1965, I am not giving the citations because all of you are lawyers. For the first time, Justice Mudholkar in his dissent uses the word basic structure. It says, I hold that Parliament cannot make amendment which destroys the basic structure of the Constitution. For the first time, we are attributing basic structure theory to the Keshwanand Bharti case, where it was discussed in detail, but for the first time it was used by Justice Mudholkar in 1965 in Sajjan Singh's case. By that time, Parliament kept on passing law, including it in the 9th schedule, making it immune from any judicial challenge. This is 65. In 1966, after the death of the then Prime Minister Shastriji, Mrs. Indira Gandhi takes over as the Prime Minister of the country. Now see the constitutional history, not the political history. I'll come to the emergency and it's the abuse of the Constitution. Now, how the government of the day plays with the Constitution, plays with the fundamental rights of the citizens, not during emergency. When we say there were excesses during emergency, we unknowingly condone or pardon the acts of the government of the day from 66 to 75. And I want to concentrate on that period also before I come to 75. In 66, There is a change in the regime in the sense that the leader came to be changed. And this discussion and debate was going on that what will happen if the parliament is permitted to change the constitution itself and the citizens are rendered remediless. They don't have any right to approach the court of law. And eventually, I'm not going into the details as to how the matter traveled, but it goes before the bench of 11 judges in Golaknath's case. Bench of 11 judges. The said bench decided by a razor-thin majority of 6/5. 6 held that no, law made by parliament cannot take away fundamental rights of the citizens, and law under Article 3 includes even the amendment to the constitution. So even if you amend the constitution and it takes away any of the rights of citizens under Part 3, that amendment itself is bad. Now, this happened in 1967, and immediate response from the government. When I say government, I include the parliament, because there was almost not absolute, but substantial majority, numerical majority in the parliament, and therefore whatever law was proposed by the leader used to be passed. The parliament passes 24th constitutional amendment. See, in Golaknath case, Supreme Court says that even amendment of the constitution cannot violate fundamental rights. It's 11 judge bench judgment, though divided by 6/5. But nonetheless, the largest bench judgment till that date. Thereafter, Keshwanand came in 13 judges. Now, what they did was, the government came out with a very simple formula. They amended by our 24th amendment. They said that law would not include amendment to the constitution. So Golaknath is dumped by law, by making the law. That whenever we say law, it does not include amendment to the constitution. It means other than the amendment to the constitution. Second, they say, and very interesting and a very smart way of doing the same thing which was prohibited, and I give that credit to the legal ingenuity. Politically, it's the worst thing which could have happened to the country. But legally speaking, it was a smart move. They amended Article 31 and added one more article, namely Article 31C, and provided that if any law is made in the fulfillment of the directive principles of state policy, that would be immune from the challenge from any court of law. That happened in 1971, 24th Amendment and 25th Amendment of the Constitution, meaning thereby apparently a very extraordinary object, that directive principles of state policy, the parliament is making a law. Eventually it can end up making any law which may take away the fundamental rights. But they dumped Golaknath case, 11 judge bench judgment in 1971. Now that issue came up before the 13 judge bench of Keshwanand Bharati. See, the court is balancing the fundamental rights and the power of the parliament to legislate. And the government of the day is continuously going ahead, dumping the law laid down in favor of the people and coming out with new amendments. Since Golaknath was 11 judge, the matter went before 13 judge, and now the interesting history starts. Some of the facts which I am going to mention are not to be found in the textbooks because they cannot be written in the textbooks. They are found in the memoirs, the autobiographies of judges, autobiographies of those who argued the cases, other literature, etc. So some of the facts would be very interesting facts. Now in Keshwanand Bharti, the argument was led by the legendary Nani Palkhiwala. He was struggling because these are not the expressions I am using, but they were being used and they are being used in various literature, that there were some pro-government judges and some pro-citizen judges, not anti-government judges, pro-citizen judges. And there used to be a barrage of questions to Mr. Palkhiwala that why? Ultimately, the parliament is the creature of the constitution. If constitution permits it to amend the constitution, why should it not be permitted to do that? Ultimately, it's the will of the people which is reflected in the parliament. It was a very catchy argument that there is a document called Constitution of India. It creates parliament. It provides for Article 368. Article 368 says that parliament has the right to amend the constitution. The procedure is provided for. Two-third majority in both houses, ratification by one half of the states, etc., etc. Why can it not be done? The beauty in Mr. Palkhiwala's argument always used to be, and we have not been able, we are not lucky enough to have heard him. I have heard him in some lecture, not in the court, but he always used to use short sentences and used to give examples. He said, sir, forget everything else, no learned arguments. Let me point out certain things. The preamble says that India is a sovereign democratic republic. Sovereign means the sovereignty lies with the people of the country. Now tomorrow, the parliament were to amend the constitution and say that we will continue with this election and prime minister and cabinet form of government, etc. But let the sovereignty be shifted to the Queen of England. Technically, your argument is right that parliament has the power to amend the constitution. What would happen? It says democratic republic, meaning thereby till 1947, each adult Indian did not have the right to vote. Mind you, only some people had the right to vote. There was some educational qualification prescribed. Only graduates or something. We are not concerned with the nitty-gritties. But Palkhiwala gave an example that some parliament comes out with a law amending the constitution saying that henceforth only taxpayer will be voters, or only graduates will be the voters, or on a particular community only will be able to vote. What would you do? It destroys the democracy. And you will have to say that democracy is the basic feature of the Constitution of India. We are a republic. Somebody may say that we are not concerned, we are not interested in republic form of government, and we may do away with republican form of government. We'll go for some other form of government. Why can it not be done? That took the judges, that shook the judges, that yes, there is something in the argument. He advanced two arguments. A, he said that 368, Article 368 amending power, you retain, but you read an implied limitation in the parliament not to do something which is never envisaged by the founding fathers. But the second argument was that even if the parliament had the power to amend the constitution, it cannot do so without, it can do so without disturbing the basic feature of the constitution. Now, what was the reaction of the government of the day? Now, this is 1973, and the interesting part starts. The judgment of Keshwanand Bharti was delivered on 24th of April 1973. 24th of April 1973. The Chief Justice of the day was Justice Sikri. 24th of April 1973 was the last day for him to demit the office. The convention is that when the Chief Justice of India is to retire, before 30 days, before a month, the government notifies his next senior most judge as to be Chief Justice of India. The government in 1974 did not notify any name. There were 3 judges below the Chief Justice of India, Justice Sikri, namely Justice Shelat, Justice Hegde, and Justice Grover. On 24th of April 73, in the morning, a meeting of the Cabinet Committee is held, headed by the then Prime Minister, Mrs. Gandhi, and a decision is taken to supersede the 3 senior most judges, Justice Shelat, Justice Hegde, Justice Grover, and to make Judge number 5, Justice Ray, as the next Chief Justice of India. And that is heard by Justice Hegde from where? In the news of All India Radio in the evening of 24th April 1974. It was a shocker for everyone. They went, met the Chief Justice of India. He could do nothing because that was not within his domain. And he took over. There are writings during the day which mentions that everything was pre-planned. Justice Jagmohan Reddy has written his autobiography wherein he says that a week or two before 25th of April 1973, there was a dinner, official dinner, in which the then Law Minister Kumar Mangalam congratulated Justice Ray, saying that congratulations, Justice, after 2 weeks. Nobody understood why number 5 is being congratulated. But it was already decided that Justice Ray would decide in favor of the government and the remaining judges would not decide in favor of the government but would hold that you cannot amend the constitution so as to destroy the basic structure of the constitution. At this stage, I'll point out something else. When Janata government came after the debacle, after the emergency in 77, there was a move. All of you are aware about the judgment in ADM Jabalpur versus Shashikant Shukla. That judgment held that if a person's personal liberty is taken away, except in accordance with law, he has no protection under Article 21 of the Constitution of India. A very bad judgment of the day, where Justice Khanna dissented. During the government of Morarji Desai, there was a move that those judges who signed the judgment of ADM Jabalpur should also be superseded by us. But I do not know whether I can say this, that it was not done. Let us put it that way. Any other adjective may be a little counterproductive. Now, see the power of the government of the day. When somebody talks about the interference, etc., etc. When Justice Ray takes over as the new Chief Justice of India, suddenly on 10th of November 1974, 13-judge bench is again constituted to review Keshavanand Bharti. Nobody had applied for review. Nobody had filed the review petition. It comes up. One of the judges, out of curiosity, said that, why is this matter listed? Who filed review? Nani Palkhiwala said, I am petitioner, I have never filed review. And he started raising preliminary objections. Naren Day, the government counsel, the then Attorney General, started dealing with the objections, preliminary objections. But the question was, at whose behest you are entertaining this review petition? Why have you constituted 13 judges bench? The matter was heard on 10th and 11th of November for full days. At the end, Chief Justice Ray says that possibly Tamil Nadu has filed a review. The Advocate General of Tamil Nadu gets up and says, we have not filed any review. He said, then possibly Gujarat has filed a review. Gujarat Advocate General was present, and this is what is documented, not in the judgments, but in various other contemporary documents. He gets up and says that Gujarat has also not filed any review. In fact, if Gujarat would have asked me, I would have advised them not to file the review. It's a correct decision. The bench disperses, comes on the next day at 10:30, and without any reason, Chief Justice Ray says, bench is disbanded. The review is saved. The review is not taken place, and the Keshavanand Bharti still remains a good law. Now comes the interesting part, and from where the roots, the seeds of emergency were sown. Mrs. Gandhi contested election in Uttar Pradesh, and her election was challenged by her opponent Raj Narayan. We are all aware of it. Justice Sinha, the sole single judge. See, there are several unsung heroes who have fought for the democracy, who have fought for the purity in public life, who have fought for our fundamental rights, but they are not remembered today. That lone single judge of Allahabad High Court declared election of Mrs. Gandhi to be unconstitutional, ultra-virus and invalid, and held her guilty of malpractices and debarred her for 6 years. It was a shocker for the entire nation because she was the most powerful leader then. She had always been a powerful leader. Now, the fact which I am going to tell you will not be found in any journals because that is stated by Justice Krishna Iyer in his autobiography or memoir. It was during the vacation that the Allahabad High Court pronounced its judgment and stayed its own judgment for 15 days, very fairly. Justice Sinha was very fair. He didn't give it effect immediately. He gave an opportunity to Mrs. Gandhi to approach the Supreme Court of India, which was done. But the vacation judge was Justice Krishna Iyer. Justice Krishna Iyer writes that he received a call from Mr. H.L. Gokhale, the then law minister of the Mrs. Gandhi government, that I want to come and meet you. Maybe he was little suspicious and therefore said that for what? Generally, the judges don't ask law ministers or law officers why you want to come. That's the respect and a kind of a faith that they would not be coming for something unconstitutional. On insistence, just Mr. Gokhale says that the Prime Minister's election is set aside and we are planning to move appeal. He said, you need not come here. You move the appeal, you ask your lawyer to move the appeal. The appeal is moved during vacation. Incidentally, Nani Palkhiwala represents Mrs. Gandhi. And the other side, Raj Narayan is represented by Mr. Shanti Bhushan. The matter is heard for the full day and Justice Krishna Iyer refuses the stay, but permits Mrs. Gandhi to participate in the parliament both as a member of parliament and also as a prime minister, but without any right to vote. And this order is dated 24th of June 75. Please mark the date, 24th of June 75, and the emergency is declared on 25th of June 1975. Next day. The Constitution provides for declaration of an emergency because there can be an emergency in the country, but there was none. This was the only intervening factor, and on 25th of June 1975, the emergency is declared. During emergency also, now comes the abuse of the Constitution during emergency. How the Constitution is abused. The Parliament comes up with 39th constitutional amendment when the appeal of Mrs. Gandhi, which was admitted, was pending. It says two things. A, in the constitutional amendment, the Constitution is amended, and please see what it says. It says, if if the Prime Minister or Speaker, their election is set aside by any High Court, it will not be given effect to unless it is examined by the Supreme Court of India as per the law which the Parliament is yet to make. So, Supreme Court will examine the decision of the High Court setting aside the election of the Prime Minister or the Speaker, not on any other grounds, but only on the grounds which the Parliament would permit it to do. SC has no role. And second, that is Election Law Amendment Act 1975, validating the election of Mrs. Gandhi. This is the abuse of the power. One election which was declared void by a judicial order of a High Court, the highest judiciary of the state, is invalidated by an act of Parliament. Matter again goes before 5 judges bench. Now, Nani Palkiwala returns the brief because by that time the emergency is imposed. He appeared on 24th when emergency was not there, and therefore Ashok Sen appears. Ultimately, Mrs. Gandhi succeeds. His election is upheld on other grounds, but this 39th amendment by which she gave immunity to the election of Speaker and the Prime Minister is declared to be unconstitutional. This is a blatant abuse of the Constitution during the emergency. Now, immediately after 10 days, the Parliament comes with 41st Amendment, which says that if any criminal action is taken against the Prime Minister, the President or the Governor, no action can be taken against them for their lifetime. So even if a person has become a Governor or a Prime Minister or a President for a day, he is immune from any legal proceedings so far as criminal offences are concerned. And they came out with 42nd Amendment, which says that let us amend Article 368 itself. The amending power itself is amended. The very source is amended to show that once a constitutional amendment is passed as per Article 368, no court can examine the validity of that constitutional amendment. That is the amendment made in the Constitution itself, in the provision providing for the amendment of the Constitution. It also says, to do away with Keshavanand Bharati, that there is no fetters on the power of the Parliament in amending the Constitution. So no basic structure, nothing. And third, it adds Article 31C, again saying that if any law is made to give effect to the directive principles of state policy, it cannot be challenged on any ground, including grounds of violation of fundamental rights. Unfortunately, this amendment, 41st Amendment and 42nd Amendment, though brought by Mrs. Gandhi during emergency, remained as they were even during the Janata government, and the only reason was they didn't have the sufficient majority in Parliament, because when you need a special majority for amending the Constitution, you need a particular majority to declare that, to repeal that constitutional amendment also. That eventually came to be declared unconstitutional unanimously in 1980 in Minerva Mills case. So we start with 66 when constitutional abuse started. The court, by and large, barring the initial period, protected the fundamental rights of the citizens and resisted any attempt of the elected government to encroach upon the fundamental rights. But what happened during the emergency, and at the end of my talk, I would like to remember some of the unknown names who have done amazing work during emergency, but we have not been able to recognize them. We remember JP, Jayaprakash Narayan. We remember our political leaders. We remember Justice H.R. Khanna, whose contribution was immense. But there are people, the unsung heroes, who became the victim. 250 journalists were jailed. As you've seen in the exhibition, more than 30,000 arrests which took place. When we say ADM Jabalpur was wrongly decided, all of us say ADM Jabalpur was wrongly decided. ADM Jabalpur says that no, once emergency is in force, even if your personal liberty is curtailed without following the process of law, you have no remedy. That's the law in ADM Jabalpur. Now declared to be not a good law by Chief Justice Chandrachud, declaring his father's view to be not a good law, a history by itself. But have we ever thought from whose judgment ADM Jabalpur arose? It was judgment of Madhya Pradesh High Court, where Justice A.P. Sen said that despite existence of the emergency, fundamental rights are not curtailed and you cannot deprive somebody of his personal liberty except in accordance with law. That was set aside. So first unsung hero is Justice A.P. Sen. It was he who took the decision. Second, there was a journalist called Kuldeep Nair. If any one of you are practicing in Delhi High Court, Rajiv Nayyar is the senior advocate. His father was a very eminent journalist, and he was a very open critic of the government of the day, and particularly Mrs. Gandhi. He was detained. His detention came to be challenged before the High Court of Delhi, and a bench consisting of Justice Rangarajan and Justice R.N. Agarwal held in his favor that despite existence of emergency, fundamental rights still exist and he could not have been arrested or detained except in accordance with law. What happened? Justice Rangarajan was immediately transferred to Guwahati High Court. The most unfortunate person, Justice R.N. Agarwal. He was an additional judge. All of you are aware, some judges are appointed as additional judges, yet to be confirmed, and some are appointed as confirmed judges. He was an additional judge. His High Court judgeship was not confirmed, and he was demoted as a sessions judge. The real hero of emergency. By and large, if you study the material during emergency, you will find that it is the high courts of the country which have stood by the citizens, and by and large, the Supreme Court of India has let the citizens down, by and large. We are not naming. We have the names which bench did what, but that's not the purpose, that's not the occasion here. As a matter of fact, it is believed Om Mehta was the Minister of State for Home during emergency. He is supposed to have heard one gentleman telling or directing, let us lock up the high courts. And he meant it. He meant it because every high court was interfering. It came to the notice of Mr. Siddharth Shankar Ray, a very eminent counsel himself and a very eminent politician, once upon a time the Chief Minister of Bengal, and he understood the seriousness of it and therefore he could prevent it. But Sanjay Gandhi rebuked him for having prevented it. Otherwise, there was a direction to lock up the high courts. Similar fate, Bombay High Court. In Bombay High Court also there was a judge called Justice U.R. Lalit, if you are familiar with the name, father of the earlier Chief Justice of India, Justice U.U. Lalit. He was also an additional judge and he passed orders in favor of illegal detentions during emergency. He was an additional judge, not confirmed. And as the luck would have it, he shifted to the Supreme Court and flourished. He was one of the most eminent counsels on the criminal side in the Supreme Court of India, but a victim of emergency. Incidentally, he was the founding president of Adhivakta Parishad, Mr. Justice Lalit. Now, how the bar acted. Bombay Bar, immediately the Supreme Court Bar Association passed the resolution condemning this. Bombay Bar passed the resolution and they proceeded on strike. They met the Chief Justice of India saying that we are going on strike. Even the judges were sympathetic to the bar, fighting against the emergency. And the Chief Justice of the day said that all right, will not dismiss any matters for default if you are on strike. Rarely this happens. Meaning thereby, even the judiciary of the day may be bold, may not be bold, but they were sympathetic to the fight against the emergency. A conference was held in Ahmedabad under the chairmanship of the former Chief Justice of India, Justice J.C. Shah, attended by none other than Mr. M.C. Chagla. And a course of action was planned how to deal with emergency. In Bombay, some lawyers under the banner of Committee of Lawyers for Civil Liberties, they wanted to organize a function in one hall called Jinnah Hall. The permission was denied by the government of Maharashtra and they even invoked Defense of India rules. Immediately a petition was filed by Soli Sorabji and the judge was very, very savage. Judge was Justice Tulzapurkar. That what are you doing? You say that 5 people can't gather together? A husband, wife and 3 children can't come out? They are 5? A Muslim man who has married 4 wives cannot go out with his family? I set aside the order denying the permission. By speaking judgment, the division bench set aside. Unfortunately, the matter was carried in the Supreme Court and not only the operative part was stayed, even the judgment was stayed, which according to me as a student of law, I understand the intention was that no other High Court follows the suit because the judgment itself is stayed. There are several lawyers. It is believed that there are approximately 65 to 70 judges who were transferred during emergency. And the Chief Justice of India had no role except to sign the transfer orders when so instructed by the government. 65 to 70 High Court judges, the constitutional functionaries, we are not talking of bank clerks or cashiers, being transferred en masse. Now, even in Delhi, Mr. P.N. Lekhi was arrested, Justice Rama Joyce was arrested, but importantly, about 200 lawyers were arrested and approximately 200 lawyers' chambers in this Hazari Court were demolished only because they were protesting against the emergency. Friends, when we inherit freedom, we take freedom for granted. Our generation is the generation which have inherited the second freedom, and when I say second freedom, the second freedom started from 77. The constitution was really under threat. The democracy was really under threat. The independence of judiciary was really under threat. It was lawyers, judges, the judiciary, academics, journalists, and common men which came together and brought the nation out of this dark period. Henceforth, whenever you have to discuss, whenever somebody says, what is majoritarian regime, what is danger to the democracy, and what is danger to the independence of justice, you have the sufficient material now to contradict them. That we are in the safest of the possible constitutional scenario and we are lucky citizens. Friends, I have exceeded my time. I am really grateful that despite the subject being very boring, You have been very, very patient with me, and you didn't hoot me down. Thank you so much.
Good evening to my fellow citizens and the honorable speakers present here. My name is Anisha Man, and sir, when we talk about emergency in the constitution, I think it's inevitable that we do not talk about the freedom of the press. Like as you had mentioned, a lot of journalists were jailed at the time of the emergency. But in the present times also, we have been slipping the ranks of the Freedom Press Index. We have come on 161st rank out of 180, even beneath Afghanistan, Sri Lanka, Nepal. So I would like for your intake on that.
Two things. First of all, you are absolutely right. We cannot forget the press censorship during emergency, and I didn't dwell much upon it because I was more on the legal questions. But the press suffered the most. They were even burned. There used to be pre-censorships. So far as present scenario is concerned, this was suggested by one of the judges of the Supreme Court that yes, according to one survey, India is slipping down the index. And my answer was that it depends upon which survey you are relying upon. The survey which puts us, the survey which puts India below Afghanistan speaks more about its survey's credibility than India's credibility. I can have my own survey where I can put India at number 1. So don't go by the survey. There are generated surveys and they are rarely true. We are abusing our leaders in print. There cannot be any further abuse of the power of speech than what we are enjoying at times. So there is no freedom curtailed in the present scenario, and in any case it can't be curtailed.
Very well said, sir. Any further questions from anyone? Please hand over the mic there.
Good evening, sir.
Yes.
I'm Ishan Kapoor. I'm an advocate. My fellow or member from the audience talked about the press, but probably she forgot that how Bahadur Shah Zafar Road's lights were switched off. So and how every news first going on air was read by a certain person.
That's pre-censorship.
Yes,
that's what I said.
yes, pre-censorship.
Pre-censorship.
And how lights were cut off if the articles were not appropriate. But whenever one particular person is in charge of all the affairs in a government, in that time there might have been certain policy decisions which have been taken, not in respect of rights of citizens per se, but when considered in respect of industries. So if you could dwell upon some of those aspects, if you remember.
The question is not what this government of the day always continue to function. The moot question is, can the government of the day function even for the betterment of the people while curtailing the fundamental rights of the people? Maybe some decisions might have been taken, we do not know. Those decisions were challenged. What was Minerva Mills case? Minerva Mills case was that it was a mill which challenged Article 31C. So there were decisions, but the decisions, no decision in a welfare state can be so taken that it affects the fundamental rights of the citizens and you make the citizens remedies.
Thank you. Thank you. A follow-up on this, if I can. Nowadays, with social media, all the issues crop up immediately and we get to know. But in those times, the access to was not so much. But our brothers and sisters who live in hinterlands such as Adivasis, they must have suffered badly because of these atrocities that took place and the views.
What's your question? What's your question?
The question is, how was their lives impacted, and did judiciary was able to take care of that to a certain extent or not? Because in politicians, whatever issues came up, they were taken care of, while it was related to liberty by the high courts or other aspects. But the land...
I understand your question, how the have-nots were taken care of during this period. See, have-nots, whenever their fundamental rights were violated, they used to approach the High Court, and the High Court used to protect them. They used to approach the Supreme Court, and the Supreme Court also used to protect them. The government of the day was more concerned about the political issues which they used to oppose, and they used to do whatever they can, they should not have. But I don't think the country stopped running. That's the sustenance. That's to the credit of the nation, that we could withstand even those dark times. And dark times were more dark. I dwelled more on the legal aspects of it. If you go factually, there were certain things which your generation cannot even imagine. For example, can you imagine a parliament's tenure being extended for an hour? It's completely impossible, unconstitutional. It was extended by 2 years, no elections. There are several instances. People used to be picked up and put behind the bars. The whispering was with a sense of fear. If I want to whisper something about some other person having the same name as that of the Prime Minister or the nearby in his ears, I'll be very careful that he doesn't listen to me, because he might be a stooge, he might be informing them. People really were scared. Yes. The lady.
Good evening, sir. My name is Ankita Vishwas. I'm a student of CLC University of Delhi. My question to you is, as you mentioned 42nd Amendment Act 1976, we know that there were two words which were incorporated in the very preamble of the Constitution during the very phase of emergency, socialist and secular. So, what would be your take or your suggestion to the relevance of these two terms? Can it be said as an abuse to the Constitution during the emergency? Like, was it constitutionally feasible to incorporate it during that time, and what was its relevance?
What was prohibited was something which goes against the very ethos of the Constitution. If something is added which is not contrary to the ethos of the Constitution, nobody objected, nobody challenged it.
नमस्ते सर. हाँ सर, आई एम नॉट ए लॉ स्टूडेंट, बट जैसे आपने इमरजेंसी के बारे में बताया, कुछ इस तरह की इमरजेंसी जो आज भी है, जो एक आम जन के मन में है, जैसे किसी भी देश विरोधी ताकतों के लिए रात को कोर्ट खुलवा दिए जाते हैं, तो और एक मतलब नॉर्मल आदमी है वो न्याय मांगता रह जाता है. इस तरह की चीजें ये कब रुकेंगी? क्योंकि मैं एक आम आदमी हूँ, तो इसलिए मेरे मन में ये सवाल है. इस तरह की चीजें, ये भी एक इमरजेंसी का ही तरीका है देश विरोधी ताकतों का, कि जो हमारे इस कानून को हमारे देश के खिलाफ इस्तेमाल करती है.
आप शायद इमरजेंसी का जो कॉन्स्टिट्यूशनल और लीगल मीनिंग है उससे परिचित नहीं है. वो पावर देती है सरकार को कुछ भी करने की. अब कोई जज ऐसा मानता है कि किसी की लाइफ खतरे में है और मुझे रात को खोलना चाहिए, उससे सरकार का कोई लेना देना नहीं होता, वो नहीं होना चाहिए.
लेकिन सारी जो ताकतें ऐसी है जिनके लिए ऐसा होता है, वो देश विरोधी होते हैं.
That is wrong. It's not emergency. It's not constitutional emergency.
उस सेंस में नहीं कहा, मैंने उस तरीके से कहा है, उस तरीके से इस्तेमाल होता है उसका.
वो नहीं होना चाहिए. I agree.
Well, we shall now proceed with the event. Please.
Yeah.
Good evening, sir. I am Premansh Sinha, first year student of political science at Ramjas College, University of Delhi. My question to you is, Mrs. Indira Gandhi, to an interview to a journalist from United Kingdom, has cited external and internal disturbances as the causes of emergency, how do you think she could have handled it better? And in case in today's world we deal with the same problems, is emergency the answer to this question? Is answer to this problem? Thank you.
Answer to your question would be found in the provision for emergency itself. There is a separate provision if there is an external aggression. That emergency was also imposed much before Mrs. Gandhi by Pandit Nehru during China aggression, during war. That is no justification for an internal emergency. Any person, any non-democratic leader, if imposes emergency, would have his own so-called justifications. Mr. Kumar Mangalam, the law minister of Mrs. Gandhi, even justified the emergency on the floor of the parliament. There would be justifications, but there were no circumstances which cannot be taken care of by an effective and democratic government without imposing emergency.
Good evening, sir. I'm Nandini. I'm a law student. I would just like to add to the discussion that we just had that I think it was the absolute disregard of Mrs. Gandhi for the constitution, and which was demonstrated by the Guru Gandhi. The one that came to my mind is the
India versus Union of India, when they ruled, it's popularly known as the Privy Purses case, and how they actually backtracked against and tried to come up with a law in order to curtail and try just having their way around the constitutional mandate that is there. So I think it's that is the peak absolutism. That is.
Yes, you're right. There were many cases where the judgment was sought to be overruled by way of a legislative enactment. Thank you.
Srikal sir, I am Advocate Chiranshu, practicing in Punjab and High Court Chandigarh. I have a very basic question.
Yes, please.
We used to heard a term very frequently, undeclared emergency nowadays. So if you can throw some light on the opinion of such people, like what they want to portray by denoting some terms like this.
See, your question contains.
Along with this, just if you permit me, if you allow me, along with this, this is some question out of the box. Like, I'm a first generation lawyer, so we used to heard on a collegiate system that it is an uncle-son relationship. It is out of the box topic, but if you can throw some light on it also. Like, for me to become a judge in this collegiate system, it is somewhere unclear. So if you can guide us, thank you, sir.
I'm going to answer your question. And your question had an answer in it. You say undeclared emergency. That's the portrayal. That's the impression which is given. And I'll give you one example. After the rule of Lenin and Stalin, Nikita Khrushchev became the president or the general secretary, the chief of Russia. And he was narrating the ill deeds, the atrocities of Stalin, Lenin, etc., etc. And some young man got up and said that I have a question to you. Why did you not do anything? Because you are also a member of that very political party. Are you not equally guilty? He said, my friend, you can ask me this question because there is no fear in your mind. I could not have asked that question because I would have been dead next day. You are in presence of so many people saying that according to you there is an undeclared emergency, means your freedom is intact. You can abuse anyone. So far as his uncle's son is concerned, I don't think that's the subject matter today. And there can be a better system, but that's for parliamentarians to take a call on.